Welcome to the Deep Dive. Today we're tackling something absolutely fundamental. It's about contracts, language, how we understand each other, really. It's contract interpretation. Think about this. You sign a contract. If the term in it looks perfectly clear, right? Just plain English. But maybe through emails or just the context of your deal, you and the other side knew it meant something slightly different. So the big question is, when you end up in court, does the judge just stick to the dictionary definition, that plain meaning? Or do they have to look at what you actually intended? And specifically, when does that outside stuff, extrinsic evidence, lawyers call it, get allowed in to show the real meaning? That's our mission today. We are diving straight into the case that, well, basically rewrote the rules on this.
That's right. And to really get a handle on this, we need to focus on Pacific Gas and Electric Company versus GW, Thomas Drayage, and Rigging. It's a landmark case. So our plan is, first, understand the old rule, the really strict one, then see why the court decided, this isn't working, and finally break down the exact test courts now use before they can exclude evidence about what the parties meant.
Okay, before we jump into the case specifics, let's set the scene. What was that old way of thinking? The rule that PG&E really took aim at. You called it the dictionary rule earlier.
Yeah, informally. It's traditionally known as the traditional rule or the plain meaning rule. The logic was pretty straightforward, maybe deceptively so. It basically said, if a judge reads the contract, just the document itself within its four corners, and thinks the words are clear and unambiguous, that's it. No outside evidence allowed to suggest a different meaning.
Wow. So the judge's personal understanding of the language was the absolute final word. Like, context didn't matter if the judge thought the word was simple.
Pretty much. The court in PG&E actually talked about this. They called it a sort of primitive faith in the inherent potency, inherent meaning of words. It assumed you could achieve perfect written expression. The real problem, the consequence, was that if the judge's reading clashed with what both parties actually intended, or say how a term is always used in their industry, too bad. The judge's dictionary meaning won.
That sounds, frankly, unworkable for how business actually gets done today. With specialized terms, industry customs.
Exactly, and that's precisely what the Pacific Gas and Electric Court tackled. How did they argue against this idea that words have fixed, absolute, and constant meanings?
Well, the court pointed out that language just isn't like that. It's fluid, it's mutable, words are symbols, right? Their meaning depends on context. So if a court just shuts its eyes to relevant evidence about what the parties intended just because the judge thinks a word is plain, that undermines the whole point of contract law, which is to enforce the parties' agreement. They noted that refusing to even look at evidence could lead the court to impose a meaning that neither party ever actually agreed to.
Okay, the tension is clear. Let's get into the case itself then. PG&E, VGW, Thomas Drayage. First, what are the legally dispositive facts? All right, PG&E, the utility company, hired G.W. Thomas, a contractor. The job was pretty specialized. Remove and replace the heavy metal cover on a big steam turbine. Crucially, the contract had an indemnity clause. Thomas agreed to indemnify PG&E against all loss, damage, expense, and liability resulting from injury to property connected to the work. During the job, the turbine cover fell, and it damaged the exposed rotor of the turbine underneath. Now, that rotor was PG&E's own property.
Okay. So PG&E points to the contract and says, look, all loss, injury to property, our property got injured, you, Thomas, have to pay.
That was PG&E's argument, but Thomas came back and said, hold on. They offered extrinsic evidence, things like statements from PG&E's own people, evidence from similar past jobs to prove that everyone understood that clause was only supposed to cover damage to third-party property, not PG&E's own stuff. The trial judge looked at the clause. He actually noted the language was, quote, classic for a third-party indemnity, but he saw the word all.
All means all, right?
That's what the trial judge thought. He decided the plain meaning of all property included PG&E's property. So he refused to even consider Thomas's evidence about their intent. He excluded it.
And what was the core legal issue facing the appellate court then, specifically about letting in Thomas's evidence?
The precise legal question was this. Was that extrinsic evidence, the stuff Thomas offered to show the indemnity clause, only meant third-party property admissible, even though the trial court had decided the contract language looked plain on its face and had excluded the evidence based on that old plain meaning rule?
Got it. So, faced with this, what rule of law did the appellate court apply to decide if the evidence should have been considered? Can you state the full rule and break down its elements for us?
Yes. The court established what we now call the PG&E test for admissibility of extrinsic evidence for interpretation. The rule is, extrinsic evidence is admissible to interpret a written instrument if it's relevant to prove a meaning to which the language of the instrument is reasonably susceptible. And critically, this test has two core steps, or elements you have to follow in order. First, reasonable susceptibility. The judge has to provisionally decide. Could the contract language, looking at all the circumstances and the evidence offered, fairly be interpreted the way the party offering the evidence suggests? Second, preliminary consideration, and this is key. To make that decision about susceptibility, the judge must first perform a preliminary consideration of all credible evidence offered by the parties that helps show their intention.
Thank you. Okay, let's walk through the court's elemental analysis. That second element, preliminary consideration, seems like the big shift from the old rule. But let's start with the first element, reasonable susceptibility. How did the court apply that to the phrase, all loss, damage, injury to property in this contract?
Okay, so for element one, susceptibility. The sub-rule, really the guiding principle, is that courts have to find and enforce the party's intent because, as we've said, words aren't static. Now, the application. The court zeroed in on the word indemnify itself. They pointed out that this word actually has a bit of a double meaning in law. Sometimes it refers to protecting someone from claims by third parties. Other times it can mean something closer to insurance against your own loss.
Interesting. And didn't you say the trial judge himself admitted the language looked like a typical third-party clause?
Exactly. The appellate court jumped on that. If the term indemnify often points towards third-party liability, then using the word all in front of loss could reasonably mean all third-party loss. So the court concluded, yes, the language was reasonably susceptible to the meaning Thomas was arguing for, that it covered only third-party property damage. Element one, check.
Understood. So even though the trial judge thought all was definitive, the context of indemnify created enough ambiguity, enough susceptibility. Okay, now for the second element, preliminary consideration of credible evidence. What was the trial judge's error here, according to the PG&E court?
Right. Element two, preliminary consideration. The sub-rule here is basically that a judge can't interpret a contract in a vacuum. They need to metaphorically place themselves in the same situation as the parties were when they made the deal. Excluding evidence is only okay if you could truly know the meaning just from the paper itself, which the PG&E court basically said is impossible because language isn't magic. The application here was quite simple. The trial court made a clear error. It flat out refused to even look at the evidence Thomas offered the admissions by PG&E agents, the past conduct. Why? Because the judge had already decided the contract had a plain meaning.
So the judge failed to do the required first step.
Yeah.
They didn't even peek at the evidence before deciding if the language could mean what Thomas said it meant.
Precisely. That failure to conduct the required preliminary consideration of all the credible evidence offered to determine susceptibility. That itself was the reversible error. The judge needed to consider the evidence first, before deciding if the language was susceptible to Thomas's meaning. They couldn't just rely on their own gut feeling about the word all.
And after analyzing both elements, susceptibility and the failure of preliminary consideration, what was the court's final conclusion?
The judgment against Thomas was reversed. The appellate court held that the extrinsic evidence Thomas wanted to introduce was admissible. Why? Because the trial court messed up. It didn't properly perform that preliminary consideration to see if the contract language was reasonably susceptible to Thomas's interpretation in light of that evidence.
Okay, so this is huge. The court is essentially telling trial judges, hold on, you need to check the context before you declare something plain. It's about humility, right? Your personal dictionary isn't the law if the parties clearly meant something else. Let's make this really concrete for everyone listening. Let's use maybe a slightly more visceral hypothetical. Imagine, say, an old farming case. A landlord leases land to a farmer. The contract says that after the harvest, the farmer must leave all the stubble on the field for the landlord. Okay. The landlord sues, saying, hey, you only left the little stumps at the bottom. You took all the valuable hay, the cuttings, the straw. The landlord argues stubble plainly means just the base stalks. Seems clear, maybe. But the farmer brings in evidence testimony from other local farmers, maybe old agricultural journals showing that in that specific region for generations, stubble is the common term, the trade usage for everything left after you take the grain heads, the stalks, the hay, everything. Should the judge let that evidence in?
Okay, great hypothetical. Under the old dictionary rule, probably not. The judge might just say, stubble means stubble, the short stumps, case closed. But under the PG&E rule, yes, absolutely that evidence comes in. The farmer's proof of local custom, the trade usage, is exactly the kind of thing the judge must look at during the preliminary consideration step. That evidence immediately shows the word stubble is reasonably susceptible to two meanings. The dictionary one, short stumps, and the local farming one, everything left over. Since the evidence demonstrates susceptibility, it's now fully admissible for the main event figuring out what these specific parties actually intended stubble to mean in their contract. PG&E protects the farmer from a ruling based purely on the judge's potentially limited understanding of farming terms.
Perfect. It drives home that meaning isn't inherent in the word itself. It's in how people use it in context. Okay, this has been incredibly thorough. So for our listener, maybe someone facing a contract issue or studying for an exam, how do we boil this down? Can we synthesize the PG&E framework into a practical step-by-step checklist?
Definitely. Here's an actionable framework, a diagnostic checklist for analyzing these kinds of contract interpretation problems, especially when extrinsic evidence pops up. Step 1. Identify the purpose of the evidence. Ask yourself, is this extrinsic evidence being offered to change or add a term to the contract? That usually runs afoul of the parole evidence rule, or related but different concept. Or is it being offered simply to explain or interpret the meaning of language already in the contract? If it's interpretation, you're in PG&E territory. Proceed to step 2. Step 2, apply the PG&E test, the preliminary look. The judge must provisionally consider all credible extrinsic evidence that's offered. This could be admissions, emails, prior drafts, industry standards, trade usage, how the parties acted before, course of dealing, the specific circumstances of the deal. The goal is just to see, is the contract language reasonably susceptible to the meaning the person offering the evidence is pushing for? Crucially, the judge can't stop just because they think the term was plain. Step 3. Determine admissibility. If, after that preliminary look at the evidence, the judge finds that yes, the language is reasonably susceptible to the proposed meaning, as well as potentially another meaning, then that extrinsic evidence is fully admissible. It can come into the case to help the fact finder, judge or jury, decide what the parties actually intended that term to mean.
Excellent. So we've really journeyed from this old idea of words as fixed things like magic symbols to a much more realistic understanding. Language is flexible. Context matters. And the key takeaway for everyone listening seems clear. When it comes to contracts, what matters most is the intention of the parties who made the deal. You have to look at the whole context, the deal, the industry, the conversations, not just the judge's dictionary, to figure out what that intention was.
That's exactly right. And if you think about the bigger picture, it really forces you to reconsider how you read any contract. If a word like all, how much clearer can you get, right? If even that isn't automatically conclusive, as we saw in PG&E with all loss damage. That means you should probably never assume any term is perfectly clear just by reading it in isolation. You always need to think about the surrounding circumstances, the potential for different understandings based on context. That's the real power and maybe the challenge of the PG&E rule. It forces a deeper look.
A crucial lesson. Thank you for joining us for this deep dive into the nuances of contract interpretation. Now, go forth and maybe read those terms and conditions a little more closely, thinking about context.